Welcome back to online classes. Dear students, today I am going to discuss with Indian Penal Code under section 498A. Okay, 498A explain about cruelty by husband or relatives of husband. Okay, this act explain about whoever being the husband or the relatives of the husband of a woman subjects such woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years and shall also liable to fine. Okay, as per this section I just wanted to explain. For the purpose of this section, cruelty means any willful conduct which is of such a nature as is likely to drive to woman to commit suicide or to cause grave injury or danger to life, limb or health. That means whether mental or physical of the woman, or harassment of woman where such harassment is with a view to coercing her or any person related to her to meet any unlawful demand for any property, a valuable security, from account of failure by her or any person related to her to meet such demand. Okay students, and also this section has been introduced in the code by the Criminal Law Act 1983 to combat the menace of dowry debts. Okay, by same Acts 113A has been added to the Indian Evidence Act to raise a presumption regarding abatement of suicide by a married woman, okay, to the following effect. Number 1, Bhiksha Badi vs. State of Andhra Pradesh case dated 1992 case. Okay, here in this case the drinking and late coming habits of the husband coupled with beating and demanding dowry have been taken to amount to cruelty within the merit of this section. Okay, and also what is the constitutional validity of section 498 of IPC? Now the husband and the relatives of the husband of a married woman from a class apart by themselves, and it amounts to reasonable classification, especially when a married woman and hence is a no likelihood of any evidence available. Consequently, this section cannot be said to be violative of Article 14 of the Indian Constitution. Okay. Okay students, and also what the mere demand of dowry and offence. Mere demand of dowry and offence. Here the Calcutta High Court has expressed opinion that by virtue of clause B of the explanation to section 498A, mere demand of dowry would be an offence, but for the purpose of section 4 2 subclause 1 of Dowry Prohibition Act 1961, it is necessary that dowry should have been given or agreed to be given. A leading case, Shankar Prasad vs. State of in a subsequent case under the section, it was on record but the husband accompanied his deceased wife to his in-law to ask not only for unpaid balance of the agreed dowry but also for additional dowry. This was held to be sufficient to constitute an offence under this section. The case Vade Rama Rao vs. State of Andhra Pradesh. Okay, the above dowry offence and this 498A offence, the punishment provision of this area of this IPC, where the victim was subjected to cruelty right from the inception of the marriage by the in-laws and was burnt to death within the 3 years of the marriage, and punishment of the accused was enhanced from 2 years rigorous imprisonment to 3 years rigorous imprisonment, the maximum provided under this section. Okay, and also the Nandi Kishore versus State of Maharashtra, based on this report 1995, in a case of bridge burning, the husband and mother-in-law of the victim were charged with harassment, cruelty and maltreatment and demand of dowry. The mother-in-law poured kerosene oil on her body and set her on fire. The victim's dying declaration was corroborated by medical and other evidences. The Delhi High Court upheld to sentence of mother-in-law under section 302 of IPC and 498A of IPC, and that of husband only under section 498A of IPC. The camp did not find it to be a rarest of rare case and converted the death sentence of mother-in-law into life imprisonment. Okay, that case is Shanti Begal versus State. Okay, section 304B. What is that 304B? Here, section 304B is dowry death punishment, where the death of a woman is caused by any burns or bodily injury or occurs otherwise done under normal circumstances within 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband for or in connection with any demand for dowry. Such death shall be called dowry death, and such husband or relative shall be deemed to have caused her death. And also, where commits dowry death shall be punished with imprisonment for a term which shall not be less than 7 years, but which may extend to imprisonment for life. Okay, where the postmortem report indicated that the smell of kerosene was there in the body and even the burnt air was smelling kerosene, it was held that this fact ruled out the statement of husband's sisters that the deceased was the victim of an accidental burning while making tea, and also ruled out the remotest possibility of accident. Okay, the leading case Ashok Kumar versus State of Rajasthan was declared above sentence. Section 304B shows that this section has the four following ingredients. What is the main essential of this 304? Number 1, death of the woman should be caused by burns or bodily injuries of otherwise done under normal circumstances. Okay, the court guidelines Akala Ravinder versus State of Andhra Pradesh. Number 2, death occurred within 7 years after her marriage. Number 3, subject to harassment by husband relatives. Number 4, cruelty or harassment connection with demand of dowry. Okay, these are all essential ingredients to fulfill the section 304B of Indian Penal Code. If it is fulfilled, automatically the punishment also take as per this section. Okay students, today's section also over, this topic also over. Okay students, we'll meet you next class. Okay, bye, thank you, all the best.